Hi, my name's Bill Mason. I'm a real estate attorney in Garden City, New York. For over 25 years, I've concentrated my practice on transactional real estate. And what I'd like to do today is talk to you about things to consider once you've found a home to buy. Okay, so now you found that home and you're gonna have to make the offer. Okay, so the offer is not gonna be as simple as just putting the price down. The seller's gonna wanna know the terms under which you're willing to buy the house. So the first thing that I would consider is the down payment that you're gonna put up in contract. Okay, so what I'd like you to do is try to negotiate that you'll put up the smallest down payment possible at contract. So I know that you may consider putting up 10 or 20% total, but I'd rather you brought that additional money to the closing and only had a small down payment up at contract. So my thought behind this is in New York, the down payment is the amount that would be the damages if the buyer defaults. Now I know you don't plan on defaulting right off the bat, but you want to be able to set up a contract in a way that if things happen that are unforeseen, like you get a job out of state, or you just change your mind, or something else goes wrong, that you limit your damages. So at the beginning, I'd like you to put up as little as possible, and we'll bring the balance of that down payment to the closing. The other consideration with putting up a small down payment at contract is you're letting a third party hold the money. And although this does not typically happen, it could happen. Someone could steal the money, right? So in New York, it's very unlikely that it would happen because in New York, we have what's called IOLA accounts. And those are the accounts attorneys would typically put the down payment, although not every attorney puts their money in that type of account. And that would be a question that you should ask. If it's in an IOLA account, there's some protections that you would have through the state of New York, where if it's a different type of account, you wouldn't have any protection for the most part, other than seeking, damages against the attorney that may have stolen the money, okay? I know in other states, you see that the down payment's held by a title company. That's not so frequent in New York, or at least not in downstate New York. It may happen more upstate New York. And my consideration with that would be that it's usually held by an abstract company, which is only as good as the company that's holding the money. And so I think that's a very risky situation. And what I would do is I would ask to have the money actually held by the title underwriter, like a First American, a Fidelity, an Old Republic, as opposed to just the abstract company where it's only as good as the company holding it. All right, so that's the first thing, the down payment, okay? So the second thing you want to do is you want to then provide a closing date, when you're going to close, right? So you want to make sure that you coincide that with other things going on. So if you're selling a house and you're going to take the funds to sell to buy, so you want to make sure that you have the closing dates lined up in the contract. Another consideration is, I know out of state, a lot of times when it has a closing date in the contract, that's the actual date you close on. It's like a target date. In New York, we don't have that. We have what's called an on or about closing date typically, where it's just saying we're going to try to close sometime around that date. And it's generally understood within 30 days of that date. So you don't want to be obligated to close out of state on a certain date. And then in New York, it's just, an estimate of when you're going to close. You could, in New York, elect for something different than on or about closing date. That's called a time of the essence date, but you don't see that as frequently. The third thing that I would want to consider in my offer is that if you're getting a loan, that you want to make sure that you have a mortgage contingency clause. So a mortgage contingency clause gives you the ability to get your money back, or the down payment back, if you don't get the mortgage. Now, I know that most people will, at this point, have already met with a mortgage professional and gotten pre-approved, but that's not something that contractually obligates the bank to lend you the money. And so you want to have the protection that once the bank thoroughly goes through all the documents and they do an appraisal and everything else, that if they decide not to move ahead, that you can get your money back, okay? And then the last thing that I would discuss with the seller is, in New York, we have these things called certificates of occupancy. And what that basically is when somebody builds a house, right? When there's vacant land, you file plans. And as you build, you get inspections. And at the end, the building department gives you what's called a certificate of occupancy. And you generally don't see houses don't have certificates of occupancy, but what you do see with great frequency is once the people are in the house, they convert a garage to living space, they add a deck, they add a pool, they add an extension, or they do some other things, a detached garage, and they don't legalize that. Now, you really want to know that up front before you start spending money on an inspection or doing anything else going forward, because that would, I think, have a great amount of significance in maybe what you want to do. If you want to still buy the house, or if you want to go back and maybe renegotiate the price. So that would be the 4 things that I would consider with the offer. Okay, now you've gotten the offer accepted, and so what's next? Okay, so the next thing you need to do before you sign the contract is you need to choose an attorney. So what I would do is I would reach out to friends, family, people you work with that have bought a house before and get their opinion of the attorney they worked with so that you could get a referral to somebody. You want to make sure that when you do get the attorney, it's an attorney that concentrates his practice on real estate, not somebody that's doing a general practice or a practice that's mostly matrimonial and he does this when he gets them. You want to make sure you have an attorney that thoroughly understands all the issues, as opposed to somebody that only does it sometimes. I think this is a really important thing for you to spend some time on vetting an attorney. And when you do get the attorney, I would at least have a call with him so you can ask him any of the questions you want, see how he responds to those questions. Maybe just ask him, will I be dealing with you directly? Am I going to be dealing with an associate? Will I be dealing with a paralegal mostly? Will you be coming to the closing? All the things that you want to know, and see what your rapport is with the attorney and how you feel about the way he answers the questions before you just decide to hire an attorney. I mean, for most people, this will be the biggest purchase or one of the biggest purchases of their life. And I think that the time on choosing an attorney is well spent. Now, the second thing that you need to do, if you haven't already done this, is you want to sit down with your mortgage professional, okay? And you want to really get a good understanding of what the payment's going to be, right? You want to know what the principal interest is, what's the payment including the taxes for real estate and the insurance, okay? You want to see what kind of down payment you're going to put down. At that down payment level, will it be PMI, okay? And you want to just also make sure that it's something that you can comfortably live with. You don't want to be buying a house and then every month you're just making the mortgage payment, you're cash poor, you're always struggling. That's not a good situation to be in. You want to make sure that you buy a house where the payment is something that is comfortable for you, okay? And then in addition to knowing what the payment is, you want to know what the closing costs are going to be, okay? So most of the closing costs in New York State, like the mortgage tax and the recording fees, are all going to be pretty standard, right? So it should be very easy for anybody to go over that with you. The things you want to know before you choose a mortgage professional is what are the fees that that lender is charging you, right? So everyone's going to ask about the rate, but in addition to the rate, there's other things to consider, right? Like, are there any points? That's also known as discount fees or origination fees. Are there application fees? Are there processing fees? Is the loan you're quoting me a fixed rate loan, or is it only fixed for a certain period of time? If I lock the rate, is there a fee to lock the rate? When I lock the rate, how long can I lock the rate for? And if I don't close by the expiration of the rate lock period, how much does it cost to extend the rate? So you really want to have a good period of time to go over everything with the mortgage person you're considering using and get comfortable with them up front. Because once you've made the decision to move ahead with that mortgage person because of the time constraints in the contract, right? It's not that easy just to shift gears and move over to someone else. So you want to make a good decision up front about the attorney you're using and the mortgage person you're using. Now you have your attorney and you have your mortgage person. So the last thing you're going to need to do now is you're going to need to get an inspector, sometimes referred to as an engineer. Okay, so in New York, unless it's a new construction, the houses are typically sold in as-is condition. And what you want to do is you want to have somebody go to the house and make an evaluation of the house before you sign the contract. Now, I know in other states, there's a lot of times there's a due diligence period to do that, but in New York, there typically is not a due diligence period to do an inspection once you've signed the contract. That's more only on commercial transactions, okay? So once you do choose the inspector and you have the inspection set up, I think it's invaluable for you to go to the inspection. You don't have to be there for the entire inspection because it does go on for a couple hours. But I would be there at the end of the inspection so you could have some time to sit with the inspector and have him give you a candid assessment of what he thinks of the house. These inspectors, just by the nature of their business, they're out in the field a lot, and after the inspection, sometimes it can be difficult to get in touch with them. And a lot of the times the reports are voluminous, and you start reading through the report and you wind up having a lot of questions. So if you could just get that 15 or 20 minutes with the inspector when you do the inspection, I think it's invaluable. I would also choose an inspector the same way I was going to tell you to choose an attorney. Do it by a referral, okay? And I would also choose an inspector that can do a termite inspection at the same time. Okay, so now you have your attorney, you have your mortgage person, you've done your inspection, and you're ready to sign the contract. Okay, so what will happen next is your attorney will have you come in to sign. I think it's important that you spend some time going over the entire contract. I would not blindly sign the contract. And some of the clauses in the contract that I would tell you to ask about and spend some time are one, the mortgage contingency clause. Now, the reason I'm saying that is the mortgage contingency clause is all in the verbiage in the contract. The fact that you have a mortgage contingency clause doesn't mean that no matter what happens, you get your money back, okay? So most attorneys in New York, they use this Bar Association approved form, and the form generally makes the buyer's obligations to close and go forward more contingent on getting what's called the commitment letter, as opposed to getting the commitment letter and clearing any conditions that the bank may have in the commitment letter before that they would actually lend you the money. Okay, so you want to be able to make sure that that mortgage contingency clause is more contingent on you getting the commitment letter and clearing all the conditions and getting the money, as opposed to just getting the mortgage commitment letter, which may have a condition in there you cannot clear. So I'll give you an example of some of the things that are in the form that you would probably want to have taken out. So it typically says in the form that you'll pay any outstanding debt to satisfy the bank. So if you had a condition in the commitment letter that said you had to pay off a student loan, a car loan, or a credit card, you may not be able to do that. And if you don't have that language out of the contract, you may be in trouble when it comes time to get your down payment back if you want to cancel. Another part of that contract is it says in there that you'll clear any customary condition. Well, that's pretty broad language. What I might consider customary, you may not consider customary. So I really don't like that language. I almost basically always take it out of the contract because it's just too ambiguous. So you really want to have your attorney try to get all these requirements for you to do things to clear conditions out of there in advance, because you don't want to be on the hook to clear a condition you can't clear. What I usually try to do is I usually try to cross out all those conditions in the contract that you're obligating yourself to clear, and I say that you'll use your reasonable efforts to clear any condition. If after your reasonable efforts you can't clear the condition, that you can get your money back. So you really want to understand what it says in there about that mortgage clause and how you get your money back if something goes wrong. Okay, so then the next thing I think you should go over in the contract is the clauses that relate to violations and certificates of occupancy. Okay, so in Long Island, you typically don't see that many violations on property, but when you're dealing with Manhattan or any of the 5 boroughs, you see them with great frequency. So you want to make sure that the seller's obligated to clear any violations that are on the property, and you want to make sure that you go over with your attorney that he orders all the appropriate searches to make sure that all the violations would be exposed in the titling search. The second thing you want to make sure is that the seller's going to deliver the house to you with all the correct certificates of occupancy in place. So what the certificate of occupancy is that when someone builds a house, they file building plans, they get a building permit, and the town comes in, they do inspections as the house is built, and then once the house is completed, they sign off on the house, allowing it to be occupied, and they give what's called a certificate of occupancy. But what happens with great frequency in New York is people live there and they decide to put an extension on the house. They make a detached garage. They convert the garage to living space. They add a deck. They add a pool. They do all types of different things, and they don't want to incur the expense of filing a permit, or they're afraid their taxes will go up, or they just don't do it, right? So you want to not inherit somebody else's problem. You want to make sure that your attorney has it in the contract that they're going to get a certificate of occupancy for everything. I usually put in there that the seller will deliver a certificate of occupancy or equivalent for all the structures as they presently are, okay? I think this is an important thing. A lot of times people try to downplay the insignificance of a missing CO for a garage or a missing CO for a deck, but sometimes it could turn into a bigger hassle than you think to legalize it, and also a much bigger expense. So I think that's an important thing to address with your attorney. When the attorney gets the certificate of occupancy search back, the certificate of occupancy themselves are not terribly descriptive by their nature. So I think it's a good idea that your attorney would order the building plans and see if you can get copies of those. They're not always available, but something we automatically do to make sure that we have them if we can get them. Get the property card. That's also something else that can help you out with trying to make determinations if structures have been added or not when it's not so apparent by what the certificate of occupancy says. And another thing I think that you should discuss with your attorney is as part of the closing process, you're going to get what's called title insurance. So title insurance typically does not cover you for zoning issues like certificates of occupancy or violations. But there is a policy in New York that a lot of attorneys don't even know about. It's called the TOPE policy. It's slightly more expensive, but it would give you certain protections for these issues. And I'm a strong advocate for that. And I think that it's something you should discuss with your attorney. I think that you'll see that if you're going to have a headache after the closing, it's most likely going to be a CO or a violation issue. So you want to make sure that it's thoroughly investigated and addressed now, so you don't wind up inheriting one of the seller's headaches. So another thing that comes up in the contracts too is the seller typically likes to hold over after the closing for anywhere from 5 to 7 days, so they can take the money from the closing and use that money to buy the next house. So most sellers don't have the money to buy another house until they've sold the house that they're living in, okay? So the issue with that is that you've closed on the house, now it's your house, and you have somebody living in there. So there'll be what's called a post-possession clause, and you want to go over with your attorney what the terms of the clause say, right? So I think that you want to make sure that you have a sufficient escrow that protects you if the people don't move out or they damage the house. I can't tell you how many times I see an attorney agree to an escrow of $1,500 or $2,500 or $3,500 for a post-possession clause on a $600,000 or $700,000 house, where there's a lot of liability if the person doesn't move out and you have to evict them. And in New York, the process is not only lengthy, it's also expensive. So I usually try to negotiate more like about $7,500 or $10,000 and add into the contract that will be entitled to a reasonable attorney's fees and any additional costs if the escrow is not enough to cover everything. So you really want to make sure you have a clause that protects you. I know it's not something that people like that the people have to hold over, but just it's a fact of life that most people need the money to buy another house. And so you just want to make sure that the clause in the contract protects you. If something goes wrong, typically there's nothing that goes wrong, but you want to make sure that you're protected, okay? And then the last thing you want to discuss with your attorney is any issues that came up in the engineer's inspection. So when you did the inspection, you have to probably feel like there's going to be some things in just about any house if it's not a new construction. But if you find things through the inspection that are of a nature that it makes you really step and think about, did you offer too much for the house, or you just really weren't expecting a big expense like that, like a hot water heater, or a roof is no good, or a boiler needs to be replaced. You want to discuss it with your attorney, or if you have a realtor involved, with the realtor, and possibly you could even negotiate a credit. I typically like a credit because I just feel like I'd rather have my client do the work on their own afterwards, so I know it's properly done. But a lot of times you just get a repair rider to the contract if people can't come up with a credit amount. And then just when you do the walkthrough, you're going to want to make sure that you were positive that the work has been done. So these would be the things that I would most focus on in the contract when you sat with your attorney. Obviously, there are other things to look at in the contract as well, but they're the things that seem to be the most problematic, and that's why I'm going over them. So you basically want to look at that mortgage clause, you want to look at that CO clause, and also what it says in there about violations as well. You want to talk about the engineer inspection with your attorney and add anything to the contract that you're expecting to have repaired or get a credit for, because the houses are sold as is typically in these contracts, and you want to talk about that post-possession clause, okay? So if you feel like all the things look good in the contract, you'll sign the contract, and you go forward with working on your mortgage, and the attorney will go forward with investigating the title, and then eventually you'll go to a closing and you'll own a home. So I hope you like the content I gave you today. If you have any ideas for any other content, I would love for you guys to comment and let me know. And if you like what I did here, if you could please like and subscribe, it helps the channel out. Thanks very much.